Let me ask you something, and I want you to really think about this. Have you ever been told that a living trust is the single best thing you can do for your family? That if you don't have one, you're basically setting your loved ones up for a nightmare? You've probably seen videos just like this one, or maybe a friend told you over dinner, or you read something online that made it sound like a living trust is the magic answer to every estate planning problem out there. And honestly, I get it. Living trusts are powerful tools. They can help families avoid probate, keep things private, and make the transfer of assets so much smoother when someone passes away. But here's the thing that almost nobody talks about. A living trust is not for everyone. In fact, for some people, setting up a living trust is a genuine waste of money. It can actually make things more complicated, not less. It can create headaches you never saw coming and cost you hundreds or even thousands of dollars for something you flat out don't need. Now, I know that might sound surprising. It might even sound a little controversial, because the internet is absolutely flooded with content telling you that everyone needs a trust. But that's just not the reality. The reality is that your estate plan should be built around your life, your family, your assets, and your state's laws, not around a one-size-fits-all piece of advice from someone who doesn't know your situation. And today, I'm going to walk you through 7 specific types of people who should probably think twice before spending their hard-earned money on a living trust. Before we go any further, I want to be really clear about something. I'm not an attorney. I'm not a financial advisor. Everything I share in this video is general education to help you understand how estate planning concepts work in the United States. Laws vary significantly from state to state, and your personal situation is unique. So please, before you make any decisions about your own estate plan, sit down with a licensed estate planning attorney in your state who can look at the full picture and give you advice tailored to you. That said, the information in this video can help you ask better questions and avoid spending money on something you might not need, and that is incredibly valuable. So here's what you're going to understand by the end of this video. You'll know the 7 situations where a living trust is probably unnecessary or even counterproductive. You'll understand why a simple will or other basic tools might serve you better, and you'll have the confidence to walk into an attorney's office knowing what to ask for instead of just accepting whatever package they recommend. If that sounds useful, go ahead and hit subscribe so you don't miss the next video, because we put out new content every week to help you protect your family and your legacy. Alright, let's get into it. Number 1. If you're a young, healthy adult with minimal assets, you almost certainly do not need a living trust right now. I'm talking about someone in their 20s or 30s, maybe even early 40s, who is renting an apartment, has a modest savings account, maybe a car, and perhaps a retirement account through work. That's it. No real estate, no business, no complicated investment portfolio. For someone in this stage of life, the primary purpose of a living trust, which is to avoid probate on major assets, simply doesn't apply. Probate is the court-supervised process of distributing a person's estate after they die. And yes, it can be slow and expensive, but probate is mostly a concern when there are significant assets that need to go through that process. Things like real estate, large bank accounts, or valuable personal property. If your estate is relatively small, many states have what's called a small estate affidavit, or a simplified probate procedure that lets your family handle everything quickly and cheaply, sometimes without even going to court at all. In some states, estates under a certain dollar threshold, and these thresholds can range from $20,000 to over $100,000, depending on where you live, can be settled with just a simple form and a death certificate. What does a young person with minimal assets actually need? In most cases, a basic will, a durable power of attorney, and a healthcare directive will cover you. A will says who gets what. A power of attorney names someone to handle your finances if you become incapacitated, and a healthcare directive tells doctors what you want if you can't speak for yourself. Those 3 documents together can cost a fraction of what a full living trust package runs, and they'll do the job just fine until your life gets more complex. Save that trust money. Put it toward building your future instead. Let me paint a picture for you. Imagine a 28-year-old named, let's call her Sarah. Sarah just started a good job. She's renting an apartment in the city, and she has about $15,000 in a savings account and a 401k through her employer that she just started contributing to. Sarah read online that she needs a living trust, so she went to an attorney and paid $2,000 to set one up. But here's the problem. Her 401k passes through a beneficiary designation, not through any trust or will. Her savings account could easily be set up as a payable on death account, which also skips probate entirely. And she doesn't own any real estate. So what exactly is the trust doing for her? Essentially nothing. She spent $2,000 on a legal document that has almost no assets flowing through it. A simple will, a power of attorney, and a healthcare directive would have cost her a few $100s and covered her completely. That money she saved could have gone straight into her emergency fund or her retirement account. Number 2. If you live in a state with a simple, fast, and inexpensive probate process, a living trust may be solving a problem that barely exists for you. This is something that a lot of people don't realize. Probate is not the same everywhere. When people talk about probate being this horrible, expensive, drawn-out ordeal, they're usually thinking about states like California or Florida, where probate can indeed be slow, costly, and frustrating. But many states have streamlined their probate systems significantly. Some states allow what's called an independent administration, where the executor can handle almost everything without going back to the judge for approval at every step. Other states have very low probate fees, and the whole process can be wrapped up in a matter of weeks or a few months, not years. If you live in one of these states, the cost and hassle of probate might be so minimal that the expense of creating and maintaining a living trust just doesn't make financial sense. Now, I'm not naming specific states here because laws change, and you really need to look at what your state's probate process looks like right now. But this is exactly the kind of question a local estate planning attorney can answer for you in about 5 minutes. Ask them, how does probate work in our state? How long does it typically take? What does it cost? If the answers are reasonable, a well-drafted will might be all you need. Number 3. If your assets already have beneficiary designations or transfer on death provisions, a living trust may be redundant for those assets. This is a big one, and it catches a lot of people off guard. Think about the assets that make up the bulk of most Americans' wealth. For many people, especially retirees, the biggest assets are a retirement account like a 401k or an IRA, a life insurance policy, and maybe a bank account or two. Every single one of those assets can be set up to pass directly to a named beneficiary when you die, completely outside of probate and completely outside of any trust. Your 401k and IRA have beneficiary designation forms. Your life insurance policy has a beneficiary. Your bank accounts can be set up as payable on death or transfer on death accounts. Even brokerage accounts can have transfer on death registrations. If you've properly filled out all of those beneficiary forms, those assets are going to go directly to the people you named, quickly and efficiently, without probate and without a trust. Now, a living trust can still be useful if you own real estate or if you have other assets that don't have beneficiary options. But if the bulk of your wealth is in beneficiary designated accounts, you're already getting most of the probate avoidance benefit that a trust would provide, and you're getting it for free. Number 4. If you're single with no children and a straightforward estate, you're another person who probably doesn't need the complexity of a living trust. When I say straightforward, I mean you know exactly who you want to inherit your things. There's no complicated family dynamic, no blended family, no estranged relatives who might contest your wishes. Maybe you want everything to go to a sibling, or a niece, or a close friend, or a charity. In that case, a simple will can state your wishes clearly. Combined with beneficiary designations on your financial accounts and a transfer on death deed on your home if your state allows it, you can create a plan that handles everything neatly without the ongoing maintenance that a trust requires. And make no mistake, a trust does require maintenance. You have to fund it, which means retitling assets into the trust's name. You have to keep it updated as your life changes. And if you buy a new property or open new accounts, you need to remember to title them in the trust, or they'll end up going through probate anyway, which defeats the whole purpose. Number 5. If you're on a very tight budget and have a modest estate, spending a large sum on a living trust may not be the best use of your limited resources. Let me be real with you. A comprehensive living trust package from a qualified attorney can cost anywhere from $1,500 to $5,000 or more, depending on your state and the complexity of your situation. For some people, that's money well spent. For others, it's a significant financial burden for a benefit they may not actually need. If your estate is modest, if you're living on a fixed income, if every dollar matters, there are more affordable ways to put a basic plan in place. A simple will, powers of attorney, and healthcare directives can often be prepared for a few $100s. Some legal aid organizations even offer free or low-cost estate planning for seniors and low-income individuals. The key is not to do nothing. Everyone needs at least a basic estate plan, but the key is also not to overspend on a Ferrari when a reliable sedan will get you where you need to go. Consider a situation where a retired couple in their 70s is living on Social Security and a small pension. Their home is worth about $150,000 and they have some savings and a life insurance policy. An estate planning mill sends them a mailer saying they need a trust, and they end up paying $3,000 they can barely afford. Meanwhile, their state allows transfer on death deeds for real estate, their bank accounts can be set up as payable on death, and their life insurance already has beneficiaries. A simple will to handle the few remaining items, plus powers of attorney and healthcare directives, would have cost them $300 or $400 and accomplished essentially the same thing. That extra $2,600 could have stayed in their savings account where they needed it. Number 6. If you are relying on certain government benefits like Medicaid or supplemental security income, a standard revocable living trust does not protect your assets and could actually create confusion. This is a really important misconception to clear up. A lot of people think that putting assets into a living trust hides them from the government or shields them from Medicaid's asset limits. That is not how a revocable living trust works. With a revocable trust, you maintain control over the assets. You can take them out, change the trust, or dissolve it at any time. Because of that, Medicaid and SSI treat those assets as if you still own them personally, because functionally, you do. The trust does not shelter them, it does not protect them. If you need asset protection for Medicaid eligibility purposes, that's a completely different conversation involving irrevocable trusts, Medicaid planning strategies, and very specific legal rules that vary by state and change frequently. It's a conversation you absolutely must have with an elder law attorney, not something you should try to figure out on your own. But a standard revocable living trust, it won't help you with Medicaid one bit, and paying for one when Medicaid protection is your actual goal is money spent in the wrong direction. Number 7. If your estate planning needs are truly simple, meaning you have a clear plan, no family conflict, and all your bases are covered with simpler tools, then a living trust adds complexity without adding value. Sometimes, the simplest solution is the best solution. If you own a home in a state that offers transfer on death deeds, your financial accounts all have up-to-date beneficiaries. You have a solid will for anything that falls through the cracks, and you have your powers of attorney and healthcare directives in place, then honestly, what is a living trust going to do for you that you haven't already accomplished? It's not going to provide privacy because your other documents already keep most assets out of probate. It's not going to speed things up because beneficiary designations are already faster than any trust. And it's not going to prevent family disputes if there's no dispute to prevent. A living trust is a wonderful tool for the right situation, but if your simpler tools are already doing the job, adding a trust on top is like buying a second lock for a door that's already bolted shut. Now, Let's talk about some common mistakes and myths because they come up all the time. The first myth is that a living trust avoids all taxes. It does not. A revocable living trust has zero effect on your income taxes or your estate taxes. For federal tax purposes, a revocable trust is completely invisible while you're alive. Your trust income is reported on your personal tax return, and the assets in the trust are still counted as part of your taxable estate. Now, for the vast majority of Americans, the federal estate tax isn't a concern anyway, because the exemption is extremely high. But even for those with very large estates, a revocable living trust is not the tool that reduces estate taxes. That requires different strategies entirely. The second myth is that everyone who owns a home needs a living trust. Not necessarily. Yes, real estate is one of the main reasons people create trusts, because real estate typically has to go through probate if it's held in your individual name. But many states now offer transfer on death deeds, also called beneficiary deeds, that let you name a beneficiary right on the deed. When you pass away, the property transfers to that person automatically, outside of probate, no trust required. Not every state offers this, and there are some nuances, but it's worth asking your attorney about before you assume you need a trust just because you own a house. The third myth is that a living trust protects your assets from creditors and lawsuits. A standard revocable living trust provides no creditor protection whatsoever. If someone sues you and wins a judgment, your trust assets are fair game. If you have significant creditor concerns, you need to talk to an attorney about asset protection strategies, which are a completely separate area of law. So what should you actually do with all of this information? First, take an honest inventory of what you own and how it's titled. Write down every major asset: your home, your bank accounts, your retirement accounts, your life insurance, your investment accounts, your vehicles. Next to each one, note whether it has a beneficiary designation, a transfer on death provision, or whether it would have to go through probate if something happened to you. Second, find out how probate works in your state. Is it fast and cheap, or slow and expensive? This one piece of information can completely change whether a trust makes sense for you. Third, make sure you have the essentials in place no matter what. Every adult in the United States needs at a minimum a will, a durable power of attorney for finances, and an advance healthcare directive. These three documents are non-negotiable. They are the foundation of any estate plan, with or without a trust. Fourth, if after doing this homework you realize that a trust does make sense for your situation, great, go get one. But go into that attorney's office informed and empowered, knowing exactly why you need it and what it's supposed to accomplish. And fifth, review your plan regularly. Life changes. You get married, you get divorced, you have grandchildren, you move to a new state, you buy property, you retire. Every major life event is a signal to pull out your estate plan and make sure it still fits. Here's what I really want you to take away from this. Protecting your family doesn't require the most expensive tools or the most complicated plan. It requires the right plan for your life, your assets, and your state. A living trust is a fantastic instrument when it's genuinely needed, and for many families, it absolutely is the right choice. But for the 7 types of people we talked about today, simpler and less costly options may serve you just as well, and sometimes even better. The most important thing is not whether you have a trust or a will. The most important thing is that you have a plan, that the people you love know about it, and that it actually works the way you intend when the time comes. Don't let anyone pressure you into spending money on something you don't need. But please, don't let that become an excuse to do nothing at all. Your family is counting on you. If this video helped you see your situation a little more clearly, please hit that like button and share it with someone you care about. Subscribe to the channel if you haven't already, because we break down topics like this every single week to help you make smart, informed decisions for your family. And one more time, everything in this video is general education, not legal advice. Estate laws vary from state to state, So before you make any decisions, talk to a licensed estate planning attorney in your state. They can look at your full picture and tell you exactly what you need. Thanks for watching, and I'll see you in the next one.